Good morning, everyone. Hope everyone's doing well this morning. Happy New Year.
Good morning, Judge Morrow.
Good morning, Judge.
Good morning, Judge.
Good morning, Judge. Happy New Year.
Let's see. I cannot hear anyone.
Judge, turn up your volume, I guess.
Okay, let me. Okay, there we go. Can you all hear me?
Yes, good morning.
All right, good morning again.
Good morning.
Good to see everyone.
Judge, can you ask the solicitors who's supposed to be sending off the offers because I never received them?
I'm in with Miss Lewis this morning. We don't have any offers from the solicitor's office this morning. We didn't receive them. Have they been sent out as of yet?
Yes, they have. I'll send them to Miss Lewis right now.
Okay, thank you, and she'll get it to me. I appreciate it.
I would need it too, Judge. This is Miss Thomas.
Okay, good morning, Ms. Thomas, and if we can get the office to Ms.
Put
Thomas
your
also.
email in the chat, Ms. Thomas, or the solicitor's office can send it to you also.
Okay, good morning, Officer Francois. How are you today?
I'm good, thank you. Good morning, Judge Morrow. Whenever you're ready, we'll be starting with position number 19, Mr. George.
And I have hold for announcement for Mr. George. Who's representing Mr. George this morning?
Yeah, good morning, Your Honor. How are you?
I'm doing well. Mr. Bartell, it's good to see you.
Yes, sir. Good to see you too. I was speaking with Mr. George, Your Honor. That will be a not guilty plea, and we would ask reset to jail jury.
And he needs to be arraigned this morning, Mr. Bartell?
Yes, we'll waive arraignment, Your Honor. And
Okay, and if you'll file a written waiver for me, we'd appreciate it. Okay, Mr. George, good morning. I'm Judge Eric Morrow. Your case is going to be returned to the division judge. There's a waiver of arraignment that will be filed, and you'll have notification of your next hearing date, okay?
yes.
All right, good luck to you, sir.
All right, thank you, Judge.
Position 23, Jenkins.
And this is also going to be an arraignment.
That's correct, Your Honor. Same announcement. It's a reset to jail jury.
Okay. Would you like him to be arraigned, or will you file a written waiver?
I'll
Mr.
follow,
Bartell?
Judge.
Okay. Mr. Jenkins, good morning. I'm Judge Eric Morrow. A written waiver of arraignment will be filed on your behalf. Your case will be returned to the division judge, and you'll get notification of your next hearing date, okay?
Yes,
All right. Good luck to you, Mr. Jenkins.
thank you. I can talk to you. Okay, we got it.
Position 24, Johnson.
And this is a non-negotiated plea.
That is a non-negotiated plea. Correct, Your Honor, just regarding the FVIP versus anger management case.
All right. Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning, sir.
Good morning, Mr. Johnson. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Johnson. Since this is a non-negotiated plea, Ms. Bostic, may I have the history, please?
Just a second, Judge. This is position 20,
It's position 24, Antonio Johnson is my understanding.
Antonio Johnson.
And Your Honor, I did want to interject. I'm looking at it. It's actually the only non-negotiated part of it is how many days to serve. We're not in a dispute about the FVIP recommendation.
Okay. While Ms. Bostic gets the history for me, good morning, Ms. Dillingham.
Good morning, Your Honor.
You can proceed. Thank you.
Yes, Your Honor. So on December 20th, 2022, officers were dispatched to 1947 Grange Street, which is the residence of the victim, Tanya Burnett. There were reports of a domestic dispute, and when they arrived, they learned that the defendant had punched Miss Burnett in the face, causing visible bruising and swelling. And for that reason, Your Honor, we are asking for 12 months to serve. We're recommending 12 months to serve 45 days. 15 days credit for time served, balance probated, and then the FVIP and a stay away from the 1947 Grange and a no further contact with Miss Burnett.
Do you have that history for me, Ms. Bostic?
Judge, I'm still waiting for it to come up. My computer is cycling. It just popped up. I'm sorry, Judge, for the
Okay.
delay.
That's fine. Ms. Dillingham, do you have the history?
I had 3 arrest cycles coming up in GCIC, but they were 10 years prior.
Okay, no, any convictions for anything related to violence?
I did not have that. Your
Okay,
Honor.
Mr. Bartels?
Yes, Your Honor. I've spoken with Mr. Johnson. He was booked into jail on December 20th, from what I have, so this would be 15 days. His history does appear to be fairly minimal, and that was a number of years ago. I'm informed that he has currently been taking online college classes, studying computer science with Colorado Tech. Is that correct?
Yes, sir.
And he's also been working at Horizon Staffing. So he has some plans for his future. He's been working. He's been in for 15 days. We're not in disagreement with the FVIP or the stay away and no further contact, but we believe that 15 days or actually 30 days with 2-for-1 credit would certainly be appropriate. He's already been in 15 days. So we would just ask for 30 days to serve with credit for time served since the 20th of December.
Okay, Mr. Johnson, it's my understanding that in case 22 CR 008434H, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept your guilty plea, Mr. Johnson. The sentence of the court is going to be 12 months to serve 30 days, credit for time served 15 days, the balance probated, a family violence intervention program, stay away from Miss Burnett, no further contact with Miss Burnett, stay away from the 1947 Braden Street address, and no drugs, alcohol, or weapons while you're on probation. I'm going to waive the probation fees for you, Mr. Johnson, while you're on probation. And when you complete the terms, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck. Good luck to you, Mr. Johnson.
Thank you.
Position 25 and 26, Mr. Johnson.
So position 25 is negotiated and position 26 is going to be null process. Is that correct?
It is a negotiated plea on 25, Judge. I haven't confirmed about 26, but my understanding is that that's normally what's done.
Mr. Dillingham?
That's correct, Your Honor. 25 is a negotiated plea and 26 is null prost. It was a FTA, failure to appear.
Okay, you can proceed, Ms. Dillingham.
Yes, Your Honor. So on April 23rd, 2022, officers responded to Mamma Mia on the GSU campus, which is located at 78 Broad Street. This defendant was previously issued a criminal trespass warning for that location earlier that year. And he entered the property again in violation of that warning. So we are recommending 12 months to serve, 16 days, credit for time served, 8 days, balance suspended, and a stay away order from that location, Mamma Mia, at 78 Broad Street.
Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, Mr. Johnson. Mr. Bartels?
Yes, Your Honor. We would just ask the court to accept the recommendation. I've spoken with Mr. Johnson and he does understand that while this sentence is in effect, including the suspended sentence period, he can't go back to the location.
Okay.
Yes, Your Honor.
Mr. Johnson, it's my understanding that in case 22 CR 002444J, you wish to plead guilty to criminal trespass and public drunk. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Johnson. Good luck to you, sir.
Thank you, Your Honor.
Thank you.
And Ms. Dillingham, Ms. Lewis is in court with me this morning. If you'll get the null process to her, I'll get those signed or any other paperwork.
Yes, Your Honor, will do.
Position 30, Kerr.
This is also going to be a negotiated plea.
That's correct, Your Honor.
Good morning, Mr. Kerr. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, sir. Yes, sir.
Good morning. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Ms. Dillingham?
Yes, Your Honor. On December 19th, 2022, officers responded to 655 Cleveland Avenue Southwest, which is a gas station owned by the victim, Jignesh Nawanda. Defendant was previously asked not to return to that location and did anyways. And when he did, he refused to leave after being asked again. A verbal dispute ensued and the defendant ended up choking the victim, Jignesh Nawanda, and then willfully resisted officers' commands. So the state is recommending 12 months to serve, 32 days, credit for time served, 16 days, balance suspended, and no further contact with Jignesh Nawanda, a stay away order from that address, and 8 weeks anger management.
Mr. Bartels?
Yes, Your Honor. It is a negotiated plea. Just to clarify, we are in agreement with the recommendation with the 8 anger management. He understands that he would have to be on probation at least until that is completed. So we would ask the court to consider waiving the probation fee for the first 3 months and consider either going to non-reporting or terminating probation once he has completed the 8-week anger management class. And he understands that he can't go back to that location.
Okay. Any objection to non-reporting, Ms. Dillingham?
No, Your Honor.
Mr. Carr, it's my understanding that in case 22 CR 008397E, you wish to plead guilty to battery, criminal trespass, and willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with the counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Carr. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, meaning that you complete the 8 weeks of anger management, it'll go to a non-reporting status, okay?
All right. Thank you, sir.
All right, good luck to you, Mr. Carr.
Position 32, Miller.
And it's my understanding that this is a non-negotiated plea.
Yes, Your Honor.
Good morning, Mr. Miller. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you, Mr. Miller. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Good morning, Ms. Todd.
Good morning, Your Honor. The defendant in this case entered the home of Mr. Shane Frazier on December the 17th of this year while Mr. Frazier was away. When officers arrived to the home, they were able to see the defendant in the home sitting on the couch watching television. The state is recommending 12 months to serve, 36 days, credit for time served 18 days with a balance suspended, no further contact with Mr. Shane Frazier, and a stay away from his home at 317 Main Street.
Yes, Mr. Doris.
Yes, Your Honor. I had the opportunity to speak with Mr. Miller yesterday. I went over the offer as well as the accusation. We stipulate to the factual basis, venue, and ID for the purposes of this plea.
Mr. Miller, it's my understanding that in case 22 CR 008378A, you wish to plead guilty to criminal trespass and loitering and prowling. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Miller. Good luck to you, sir.
Thank you.
For the process you are.
Position 35, Price.
This is a non-negotiated plea, is that correct?
Yes, Your Honor. The only condition that's non-negotiated is the theft class.
And what's the issue with the theft class?
Mr. Price is currently experiencing issues with homelessness, and after speaking with him, I don't think that he could be, I want to set him up for success. I don't want him to have any issues staying in contact. I spoke with him about his options, and I gave him information on Gateway. He also expressed interest in receiving more information on the Salvation Army. And I think if we can resolve and assist him with his housing issues, then there won't be any future theft related issues. If you look at the warrant, he's accused of trying to walk out of the store with soap, toothpaste, and beans, and he was just hungry and wanted to stay clean. So I think if we can assist with housing, there won't be any future issues.
Okay, thank you. Good morning, Mr. Price. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes. Good morning, Mr. Miller.
Good morning. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hands down. Thank you. Ms. Todd?
Thank you, Your Honor. As the defense stated, the defendant was caught stealing from the Publix located at 595 Piedmont Avenue. The state is recommending 12 months to serve, 28 days, credit for time served 14 days with the balance probated. We are still going to ask for the theft class, Your Honor. The defendant's history does include 21 felony convictions for theft-related crimes. So therefore, we will ask for the theft class, and we're also asking for a stay away from the Publix located at 595 Piedmont Avenue.
Okay. Mr. Dominguez?
Yes, Your Honor. Again, I think the underlying issue is housing related, and I think if we can find a program that works for Mr. Price, then he'll be set up for success. I don't want anything to happen where he's unable to complete the theft class and he ends up violating, when instead of treating the symptom, we can treat the, underlying root cause of what's going on here.
Okay. Mr. Price, it's my understanding that in case 22 CR 008436A, you wish to plead guilty to theft by shoplifting, is that correct?
Yes, sir. Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your plea, Mr. Price. The court sentence is going to be 12 months to serve 28 days. Credit for time served 14 days, balance suspended. You're to stay away from that Publix, that meaning that you're not to go back to the Publix whatsoever. And I want you to accept the help of your lawyer by him helping you get into Gateway, okay? I'm not going to require you to do the theft class, but I want you to get situated with your housing and get some help, okay?
Thank you, Mr. Moore.
All right. Good luck to you, Mr. Price.
Thank you, Mr. Price. This is safety for Gateway to go. Give them this. Yeah.
Who do we have next?
Positions 42 and 43, Weeders.
And it's my understanding that Mr. Weeders is going to proceed pro se this morning.
Yes, sir, Your Honor.
Good morning, Mr. Weeders. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Of course I do, Your Honor.
Can you raise your right hand for me?
Yes, I do, Your Honor.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Nothing but the truth, Your Honor.
Okay, you can put your hand down, Mr. Weeders. Mr. Weeders, you have a right to remain silent. Anything you say can be used against you. You have the right to have an attorney present at these proceedings. Well, we have provided you with the assistance of the Public Defender's Office this morning to assist you with these charges. Is there any reason that you don't want to utilize them this morning to help you with these charges?
So, Your Honor, may I clarify those reasons, sir?
I'm sorry, Mr. Weeders, I can't hear you. Can you speak up?
I said, may I clarify those reasons, sir?
Yes, we have people here that will help you. You've been charged with battery in this matter, and they may be able to assist you more than you can assist yourself. So I'm happy to let you speak with them if you would like to do that this morning. But go ahead. What would you like to tell the court?
Your Honor,
Talk loud.
Your Honor, this case dates back to 2019.
Okay, all right. So again, Mr. Weeders, I don't want you to say anything that could possibly get you into more to waive any of your rights or anything of that nature. And I understand it goes back to 2019, but we have attorneys there that can help you. Okay, I don't want you to say anything that might, cause you to be in more trouble. You understand what I'm saying?
Your Honor, I understand my rights to the fullest. And the only thing I brought to the attention of the assigned attorney was that the statutory time and limitation for prosecution on my case had expired already. I also sent motion. I also called the solicitor's office because I was on parole at the time doing a parole violation at the particular time when they sent subpoenas for me to appear.
Okay, and so if that's the case, we can clarify all that, Mr. Weeders, and we can help you clarify that with the public defender's attorney if you will allow us to do that. So today, let me tell you what your options are today. If you'd like to speak with them, I'm more than happy to give you that opportunity. Today, you can either plead guilty or not guilty to these charges. If you plead not guilty, then your case is going to be reset or returned to the division judge, and you'll get notification of your next hearing date. If you would like to speak with the attorneys regarding the matter today, again, I'm happy to give you that opportunity.
Okay, well, if he got a negotiated plea for me, I don't want to talk to him, Your Honor. I want to plead not guilty, and you can put me on the trial calendar. Well,
Okay.
the statutory time limitation done ran out already.
Okay, oh, all right, so that's what I'll do. So I'm going to go ahead and enter your formal plea of not guilty. So Mr. Wieters, let me just say that in case 19 CR 006301A, you've been charged with battery, and in the case of 22 FTA 000085, you've been charged with failure to appear for a fingerprintable charge. Each of these charges carries a maximum penalty of 12 months in jail and/or $1,000 fine. You have the right for me to read you the accusations if you would like for me to do that. I'm happy to do it, or you can waive me reading you the accusations. What would you like to do, sir?
I waive the reading because I'm well aware of the case.
Okay, and it's my understanding that you're going to plead not guilty. Is that correct?
Correct.
Okay, I'll record your not guilty plea, Mr. Wieters. Your case will be returned to the division judge, and you're going to get notification of your next hearing date. Okay?
Thank you.
You're welcome, sir. Have a great day. Who do we have next?
Position 46, Yerby.
Good morning, Mr. Yerby. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me, sir? Do you swear, the other one, you had it right the first time. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, Mr. Yerby. Ms. Todd?
Thank you, Your Honor. On December 18th, the defendant was found sleeping inside of a U-Haul that did not belong to him at 469 Marietta Street. The state is recommending a time served and a stay away from 469 Marietta Street.
How much time has he served?
If you'll bear with me 1 second, Your Honor, I can get that for you. I apologize.
Been in jail for 16 days.
Ms. Lewis tells me it's been 16 days. Okay,
Thank you, Ms. Lewis.
You're welcome.
okay. Yes, Mr. Dodge.
That's what I had as well, Your Honor. I just wanted to.
Okay. Mr. Yerby, it's my understanding that in case 22 CR 008380F, you wish to plead guilty to loitering and prowling and criminal trespass. Is that correct? Did you hear me?
Yes, sir, but Your Honor, I didn't break the one in the truck. I just put my phone there because it was too heavy for me to carry.
Okay, Mr. Yerby. Let me just say you have a right to remain silent, and anything that you say can be, your lawyer's there. If you want to discuss something with him before I take the plea, I'm happy to give you that opportunity. Do you need to speak with him a little bit more?
No, it's all right.
Okay, so it is my understanding that you wish to plead guilty to loitering and prowling and criminal trespass. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anybody forced you to plead guilty?
No, sir, Your Honor.
I'll accept your plea as negotiated. Good luck to you, Mr. Yerby.
Thank you, Your Honor.
You're welcome.
I have positions 3 and 4. Cameron is a conflict.
Yes, Mr. Kelba, is this your case? Good morning.
Good morning, Your Honor. Yes, this is my case.
And what are we going to do? Let's see, with Mr. Cameron today?
Your Honor, Mr. Cameron wishes to persist in his not guilty pleas. We would ask to be heard on a bond reduction. I have not filed anything, a bond reduction, like paper copy as yet. So if it needs to be reset, I understand. But he currently has a $10,000 cash only bond on this case, one of the cases.
Okay, so let me, does he need to be arraigned this morning, Mr. Kelba? Or would you like to
I
follow?
have previously filed a waiver in one of the cases.
He waived on the case ending in 74, but he's never been arraigned on the one with the $10,000 cash.
Okay, so position number 4, you do have a waiver filed, I'm being told, and position 3, do you want to file a written waiver in that case?
Yes, Your Honor.
Okay, so we'll await that. And do we have his bond?
Yes. Yes, sir.
Ms. Bostic, I know that you're having some problems. Are we still having problems with the history?
Let me pull that one up. See if Kevin Campbell,
I
Cameron.
have it as well, Your Honor.
Okay. Good morning, Ms. Duncan.
Good morning. Happy New Year, Judge.
You also. Hold on. Let me see if I can get it from Ms. Bostic to begin with, and if you need to fill in something, Ms. Duncan, I'll allow you to do that, okay?
Understood.
And I have that for position 8153J, that he has simple assault and simple battery, 5,000 cash on each, totaling to 10,000 cash. And on the other position, it's a $3,500 good bond. Are we ready, Ms. Bostic?
It's still not, it's still spinning.
Okay, Ms. Duncan, would you assist the court, please?
Yes,
Sorry.
from what I have, Your Honor, this defendant has 12 arrest cycles. They're all serious crimes. I do have a 2009 conviction for aggravated assault, a 2013 cruelty to children, deprivation of necessary sustenance conviction, simple assault. That's 13 CP 136034, a 2015 entering vehicle with intent conviction, 2016 aggravated assault conviction, that's 16 SC 146528, the 2020 cruelty to children in the third degree aggravated assault conviction, that's 20 SC 176579. Your Honor, in this case, it occurred on July 31st, 2022, when officers responded to 2591 Etheridge Drive, where they encountered the victim, in all of these cases, Krishan White. I have it as CHRISHAWN, White, common spelling. She disclosed that the defendant had kicked in her door the night before, and she became terrified because she had had other problems with this defendant in the past. She feared for her life. She ran and hid in her closet, and the defendant grabbed her and held her down after pulling her out of the closet. She was able to run away and escape to a neighbor to call for help. We believe that the $10,000 cash bond in the case ending in 8153J is more than reasonable under these circumstances. We believe this defendant is at a very high risk of reoffending. He has an extremely violent history towards Ms. White. He has 5 previous arrests for aggravated assault against women. He's a serial abuser with access to weapons. 4 of those arrests resulted in convictions, as I stated previously, and 3 of those aggravated assault arrests were offenses against Ms. White. In 2019, this defendant was convicted of aggravated assault with a deadly weapon and cruelty to children against Ms. White and her daughter when he pointed a gun at her in front of her daughter. When this current case occurred, the defendant was out on bond for another open case with Ms. White, and that was 22 CR 000074. That incident occurred in August 7th of 2021, where he was arrested for punching Ms. White in the face and then fleeing from police when they arrived. On January 6, 2022, Judge Law issued a bond with the conditions of no further contact with Ms. White and to stay away from the address listed on the record earlier, which is her home. In committing the crime in this case, Your Honor, the defendant violated that no further contact and stay away order when he kicked in her door and dragged her out of her bedroom. She did state to us that she was in fear for her life upon the defendant's release, and she asked that, if there was any type of way that he could stay in jail, because she was uncertain of what he would do if he was able to receive a bond. In that case, we do have some concern in that case initially about intimidation of the witness. As I stated, she told us she's in fear of her life. And she stated that he's ignored court orders before and he's likely to do it again. So she was very, very concerned. For those reasons, we think that $10,000 cash bond in the case of 8153J is more than reasonable. Would you like me to go to the next case as to why we think that bond is reasonable, Your Honor?
Yes, Ms. Duncan, go ahead.
Your Honor, I'm only requesting the $10,000 bond be reduced. The bond in the case ending at 74, I'm not asking for that to be reduced.
Okay. So we believe that the bond in 074J is more than reasonable in this case. Because again, this incident did occur against Miss White, and it occurred on August the 7th. That was the August the 7th incident that I spoke about earlier in the recitation of the facts, where he was arrested for punching her in the face and then fleeing from officers. This incident did occur. It occurred after the initial incident with the $10,000 cash bond. So, Your Honor, we have concerns about repeat violence against this victim and this defendant's continued disregard of court orders to stay away and have no contact with this victim. Not only is he having contact with this victim, he having violent and what we believe to be unwarranted contact with this victim, Your Honor. So in this instance, we believe a $3,500 surety bond in this case is more than reasonable, given the facts as already stated on the record in regards to the risk of reoffending and the intimidation of this particular witness, as well as this defendant's extensive criminal history with those violent convictions for serious crimes. And this defendant is actually not being held on this case in particular. He's being held on the cash bond. Nothing further.
Mr. Calbar?
Yes, Your Honor. Because he's only being held on the case with the cash bond, which is the 22 CR 8153J, that's the only case that I'm going to address. He also has a felony probation hold, which regardless of what the bond situation is, I believe he'll continue to be held on that for at least some period of time. I don't believe that he has a court date on that in that yet. Although the solicitor states that the allegation that he kicked the door in, he's not accused of any crime for burglary or criminal trespass or any kind of anything for entering the house illegally. That the two accusations state only that the simple battery accusation says that he grabbed Miss White's arm, and the other simple assault allegation is that he holding her down by her arm, which there's no allegation of injury. It's a simple battery and simple assault. So in light of the less serious nature of these two cases, since they did not involve weapons, they didn't involve injury to Miss White, that's one reason why we believe that this bond should be converted to a surety bond. Further, he has no possibility of making a $10,000 cash bond, and therefore it's tantamount to him to no bond. He has shares a child with Miss White. He is able to live, if he is able to be bonded out, to live with his mother at 874 Ridge Avenue in the Atlanta, Georgia 30318. Your Honor, I would ask that it be reduced from a cash bond to a surety bond. And if the court is concerned that he might return to the Etheridge address apartment, that the court impose a ankle monitor, require that he wear an ankle monitor upon his release.
Okay, Mr. Calvo, I'm going to leave it where it is right now. If he works out the probation hold, you can certainly bring him back for a modification at a later time. So I'm going to allow him to see if he can work that hold out. And if he does, I'll entertain a modification with an ankle bracelet once he does that. Okay.
Yes, Your Honor. I will file the written waiver of arraignment. If the Madam Solicitor could, on the case ending in 7-4, I have not received discovery or a copy of the accusation in that case. If you could email me a copy of the accusation, I would appreciate it. And if you could serve the discovery, I would also appreciate that.
Mr. Kilbaugh, all discovery is e-file now, so you would have to go on the e-file website and you would have access to that.
It hasn't been e-filed.
Okay, well,
I don't have a copy. I mean, in the case ending in 7-4, I simply do not have a copy of the accusation. I've gone on to Odyssey. There is no accusation in there.
Okay, so we'll update it, and then once it's on the e-file system, you'll get notification once your entry is placed on the case, once that information is updated, if it hasn't been already.
Okay, if you could follow up on that, I would appreciate it, because I brought it to the court's attention last week. And to the, I believe, Mr. Walker was the solicitor handling it. And I do see that discovery is filed in the case ending in 8153J. And I have emailed the clerk's office to ask for a copy of that. However, in the other case ending in 7-4, I don't see an accusation that's accessible from Odyssey, and there's been no discovery filed. And I have filed entries in both cases.
Okay.
So thank you for your help.
Updated, no problem.
Okay, and you all have each other's contact information. Ms. Duncan, can Mr. Kelbaugh follow up with you at a later time after court, just to make sure he gets what he needs?
Yes, he can follow up with myself, Ms. McCutcheon, or Mr. Walker. I'll put a note to the file, and it's we have it on record now, so we'll make sure that gets updated.
Okay, we appreciate it. Thank you.
Thank you, Your Honor. That's all my business. May I be excused?
Yes, have a good day. Good to see you as always.
See you. Take care.
Okay, who do we have next?
Position 16, Mr. Friesen.
Okay, and this is going to be an arraignment.
15, Your Honor, is going to be a negotiated plea.
16,
This is 16. Good morning, Mr. McLean. This is Mr. Friesen.
I'm sorry, 16 is a not guilty, but 15 is a negotiated plea.
Right, and I believe that we're with Mr. Friesen right now. Is that correct?
Right.
Which position?
Oh, Mr. 16 is Mr. Friesen, Xavier Friesen. That is a not guilty. We would waive a formal reading of the accusation and ask the court to put him on the jail jury.
Okay. Do you want to file a written waiver, Mr. McLean, or do you want me to arraign him this morning?
If you could just arraign him, we waive the formal reading of the accusation. Just tell him that what he's facing.
Okay. Good morning, Mr. Friesen. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yeah. Yes, sir.
Okay. I'm sorry. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. You have been charged in case 21 CR 007112J with simple battery. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding from Mr. McLean that you're going to waive formal reading of the accusation. How do you plead, guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, sir.
Thank you, Your Honor.
Position 18.
This is also
Dennis Gant, same.
okay. Good morning, Mr. Gant. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, thank you, sir. Mr. Gant, you've been charged in case 22 CR 008412Y with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Gant? Guilty or not guilty? You have to say it. It's my understanding that you're going to plead not guilty. Is that right?
I saw a shrug of the shoulder just before the guilty, so I think he is not very invested in which way it goes.
Your Honor.
Yes, Mr. Gant. Mr. Gant, let me just say that you have a right to remain silent. Anything you say can be used against you. If you need to talk to Mr. McLean a little more about the resolution of your case, I'm happy to give you that opportunity. Would you like to do that?
Be glad to do so, Your Honor. From our viewpoint, it is not a time served offer, and we could put it off and see him again in jail.
Okay. So would you like to plead not guilty today, Mr. Gant? And I'll see you again at a later time?
I don't understand.
Okay. Mr. Gant, I'm going to give you the opportunity to speak more with Mr. McLean regarding your case. I think that you probably need a little bit more time, okay?
Because I don't
So,
understand it.
okay. So if you don't understand, I'm going to give you the opportunity to speak with Mr. McLean after court today. I'm going to reset your case until next Tuesday, January 10th, and I'll see you back on January 10th, and we'll move forward at that time, okay?
All right, thank you, sir.
All right.
Thank you,
I'll
Your Honor.
I'll see you next week, Mr. Gant.
Thank you.
You're
Position
welcome.
number 31, Langford.
I have that this is a conflict attorney case. Do we know who's representing?
Cafe Watson.
Okay, apparently Ms. Watson Cafe is the attorney. I don't see her on the line this morning, so we're gonna have to come back to Mr. Langford. Let's see if, can we get someone to see if Ms. Watson Cafe is gonna join us today? Okay, we'll be back with you, Mr. Langford. We're gonna see if we can get your lawyer.
Position 11 and 12, Davidson.
This is a non-negotiated plea of guilty, Your Honor.
Okay.
Ms. McLean, could you restate that announcement?
He said non-negotiated.
Okay.
Right, the issue is simply the number of extra jail days that would be fair. He's gonna throw himself on the mercy of the court on that particular issue, and we can discuss some numbers. But all the other elements of a DUI, such as RR, ADET, VIP, fine, community service, he's in agreement with the state on those.
All right. Good morning, Mr. Davidson. I'm Judge Eric Morrow. This
Morning,
is
Judge.
good morning. I'm sorry. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Okay. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Well, you can put your hand down. Thank you. Ms. Duncan?
Yes, Your Honor. As the court knows, DUI convictions have a statutory minimum requirement. This is this defendant's second in life DUI conviction. So the offer as tendered by the state is in accordance with that statutory minimum. We are recommending that the first two counts that this defendant is being held on be merged with that DUI. In regards to this defendant's history, this defendant is a multi-state offender and a Georgia convicted felon with 20 cycles going back to 2004. Most of those cycles come from driving offenses. 2007 driving under the influence of alcohol, which was a conviction which included endangering a child by driving under the influence. There's also additional offenses of carrying concealed weapons and other offenses that are not related to driving. However, this defendant also has failed to appear several times and has violated probation in the past 10 years. We also saw that this defendant may have two possible open cases out of DeKalb County, but given what the statutory minimum for a second DUI conviction is, we believe that the court should take our recommendation.
Mr. McLean?
Okay, if I might have a moment. Non-negotiated.
Ms. Lewis. Katrina.
Thank you.
You need an extra week to think about it?
No.
Okay.
I just wanna go home.
Are we ready, Mr. McLean?
Yes, Your Honor.
Okay, you're up.
We had a further little discussion, making sure that we understood what a non-negotiated plea is. Your Honor, the 90 days to serve is what his problem is, and while he does have the previous, he has about 21 days of jail that he did a couple of days this past summer, I think. This is 2018 DUI, if I recall correctly. It occurred May 23rd, 2018. And if Your Honor gives him 42 days to serve, that's 0 extra jail days. If Your Honor gives him 50 or 60, that would be 4 or 9 extra jail days respectively. He would just like to avoid the extra 24 days that is entailed in the 90.
Is there an agreement on how many days have been served, Ms. Duncan?
From what I have, Your Honor, from my research, I saw 2 days. I believe this was a citation case.
This is two days back in the summer of 2022, August 15th and 16th. Apparently on the calendar, I noted 2 days were underneath his position on the calendar. Now he's been in jail an additional 14 days. As of now. So
I
that
don't believe that, but I can check. I don't believe that he's currently serving time on these charges. I think it is.
I apologize. I meant 19, not 14.
Yes, I believe, one moment, just beg the court's indulgence for one moment.
He's in jail for these charges as an FTA.
Yes, he's serving on the FTA, but for this particular case number, it was 2 days back when Mr. McCain stated as such.
That's correct. Now he's been in jail for 19 for the FTA, which is the same for the charge that he said. No.
So how much time is he gonna get credit for? I guess that's my ultimate question. Is that 19 days or 21 days?
19 days for the FTA and only 2 days for the original charge.
Yes.
He's only gonna get 20.
I'm just saying it would be fair to look at the 19 days plus the 2 days. The 19 days technically may be on the FTA itself, which can be charged and is charged as a separate crime. But because the FTA is related to this, we would ask the court to consider it to be fair to apply it to this.
Well, it's up to the jail as to what credit they give for time served. The court just gives a sentence, and if they give credit, then it's up to them to give whatever credit they deem appropriate. Or so I
And
so I'm not sure if he's going to get credit for that 19 days through the jail. I just want to make sure. Yes, Ms. McCutcheon, good morning.
Yes, Your Honor, respectfully, that is the state's position. The state does not get caught up in the weeds with the calculation of the time. And as the court knows, the case law specifically says the state should not get caught up in the calculation of the jail time. That is for the Department of Corrections, or in this case, for the county jail, for the sheriff's office to determine. We're making the plea offer that is consistent with the statute for a 2nd and 10 DUI conviction, which is what this would be. And so that is the 90 days. Of course, knowing that the court can suspend according to the court's discretion, but that is the state's offer. And the sheriff's office will determine how much credit, if any, this defendant should get. It looks like he was originally arrested, Ms. Duncan, if I'm correct, and taken to the city jail. So he would have spent those 2 days at the City of Atlanta jail back in 2016.
correct.
Was this, I thought I saw the notation being second in life and not second in 10. Was I incorrect on that?
3rd in life, 2nd and 10, Mr. McLean. By the state's calculations, he has a 2011, 2014 prior, the instant case, which would be a 2nd and 10 conviction, 3rd in lifetime.
I'm sorry, Ms. McCutcheon, that is not him. This is his actual second in life.
This is not Mr. Amos?
No, this is.
Okay, I'm sorry.
This is Mr. Davidson.
Okay, I
So he-
apologize, in your honor.
So he has, this is the second conviction, I believe, in life. And according to Mr. Walker, this was the sentence that was congruent with the statutory minimum.
That is correct, the 90 days, and the court can probate or suspend according to the court's discretion, but a second and 10 is a 90-day sentence and 30 days, I'm sorry, of community service.
Right. Believing that he's eligible for the break, that's why he's asking for it. He would love to serve no extra jail days. His wife is sick at home. I tried to reach her. I was not able to do so, but he states to me that she is quite sick and he needs to get home. I would ask the court to also look at the age of the case. It's not the oldest case we've ever seen, but it does have some age on it.
Again, Mr. McLean, regardless of what I sentence him to,
right,
he might still be incarcerated because of what the jail decides to do. Now, do you want to take some time to figure out what that's going to be with the jail and have him reset till next week? Or do you just want me to go ahead and sentence today and you'll have to deal with the consequences?
It really might be a good idea to talk to the jail record room and see how they would calculate it. Because it's only been in the last month that we've been seeing a lot of additional separate FTAs. And so,
Okay, so whatever your pleasure is, Mr. McLean, I mean, he's probably going to be in jail till next week anyway.
let's
So,
go out 1 week. 1 week
Okay.
is great.
And Your Honor, would you like to address the FTA presently?
well, if he takes a plea next week, you all are going to non-process that, is that right?
Yes, if he doesn't, we're going to be requesting that if they ask for a bond modification, that they go back to Judge Edie.
Okay, well, I'm sorry, Ms. Duncan, I don't mean to cut you off, but we'll just address all that next week.
Okay.
Okay. All right. If that's all right with you, Mr. McLean.
Thank you, Your Honor. Yes.
And my
Lisa?
apologies, Judge and Counsel, that I was talking about a different defendant. I
Oh,
apologize.
Mr. McCutcheon, you're fine. It happens.
It does.
All right. So reset till next Tuesday. Mr. Davidson, I'll see you back on next Tuesday, sir.
Position 33, Mitchell.
I'll come back to you guys.
Position 33, who's that for?
Okay, this is going to be an arraignment.
McLean, you gotta talk.
Let's see. Good morning, Mr. Mitchell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Mr. Mitchell, you've been charged in case 22 CR 000520J with carrying a weapon without a license and possession of marijuana less than an ounce. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Doez?
We do, Your Honor, and I'll submit paperwork as soon as I get back to the office.
Okay. How do you plead, Mr. Mitchell? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir. Who do we have next?
Position 34.
And this is going to be a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Moore. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Todd?
Thank you, Your Honor. When questioned by officers, the defendant did provide a false name of Dalvin Daniel. The state is recommending a 12 months to serve 30 days, credit for time served 15 days with a balance suspended.
Mr. Doris?
Yes, Your Honor. I had the opportunity to speak with Mr. Moore yesterday, go over that offer. We accepted and stipulated the factual basis, venue, and ID for the purposes of this plea.
Okay. Mr. Moore, it's my understanding that in case 22 CR 008438A, you wish to plead guilty to giving false information to law enforcement. Is that correct?
Yes.
Can you hear me, Mr. Moore?
Yes.
You wish to plead guilty? Is that
Can you hear
correct?
me?
I can hear you now, sir.
Yeah.
And you wish to plead guilty to that charge, is that correct, sir?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you to plead guilty?
No.
Was that a no?
That's a no.
Now, I'll accept the plea as negotiated, Mr. Moore. Good luck to you, sir.
Thank you.
Who's next?
Position number 13 and 14, Mr. Denard.
Pretty quick announcement on that. He is he's in the process of hiring private counsel. He doesn't have the person hired yet, but he does not need our services.
Okay. Mr. Denard, when do you anticipate that you're gonna have your counsel hired?
Oh, I never said I would hire a private, private counselor. I was just trying to see if we're gonna give, try to give a.
I'm sorry, Mr. Denard. I can't understand you.
Talk loud. Keep your mask on, talk loud.
No, I was telling him that, I was trying to get the same plea that I was gonna get when I was on the outside world. The negotiated plea was, reduce my, the DUI to reckless driving and,
Okay, so Mr. Denard, you have two options today. If you want to speak, if you want to hire private counsel, I can reset this until next week to give you the opportunity to hire counsel. If you want to talk with the public defender's office today in regards to this matter, if you don't have counsel, I'm happy to give you that opportunity also. So
reset it.
say it again.
We can reset it.
Okay, so I'll reset you till next Tuesday to give you the opportunity to hire private counsel, okay? I'll see you back next Tuesday.
Position 9 and 10, the Spanish interpreter case.
I'm sorry, say it again?
Position 9 and 10, Spanish interpreter case.
Okay, do we have an interpreter on the line? Let's see, Miss Grace or Mr. Jordan, has an interpreter been requested for today?
Let me check, Judge.
Okay, thank you. So we'll have to come back to that case and let's see if we can get an interpreter on the line.
Position 15, Mr. Dunlap.
And what's the announcement on Mr. Dunlap?
Negotiated plea.
Okay. Good morning, Mr. Dunlap. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Yes, you can go ahead and raise your right hand. Thank you. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, Your Honor.
Okay, you can put your hand down. Thank you, sir. Ms. Dillingham?
Yes, Your Honor. This case occurred on August 29th of 2014. It was a citation issue case for when this defendant knowingly was driving a vehicle with a suspended license. He does have 3 prior arrests for driving with a license suspended. So we are asking for 12 months to serve, 46 days, credit for time served 23 days, balance suspended.
Mr. McLean?
Yes, he agrees and asks the court to accept his plea.
Mr. Dunlap, it's my understanding that in case 16 CR 008504A, you wish to plead guilty to knowingly driving on a suspended, canceled, or revoked registration, driving while your license was suspended or revoked, and failure to have license on person. Is that correct?
Listen to the court. Yes, it is. I read it.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not understanding the day. I thought it was gonna be suspended today.
It's, you get 23 days credit, you multiply it by 2, that takes care of the 46 days of time served. That's balance extended.
okay.
Just listen carefully, please. All right.
Okay, you have everything clear, Mr. Dunlap?
Yes, sir. Yeah.
Okay, are you under the influence of any drugs or alcohol this morning?
No,
You've been represented by counsel. Are you satisfied with his representation?
yes,
You understand you have a right to a trial by jury on these charges, and not by pleading guilty to them, you're giving up your right to a trial by jury?
yes, sir.
Has anybody forced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Dunlap. Good luck to you, sir.
Can we do, position number 27, Johnson?
Okay, and this is gonna be a non-negotiated plea.
That's correct, Your Honor.
He's right here. For North.
No, hi, Mr. Johnson. Can you hear us?
Yes, sir.
Okay.
All right, good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Let's see, since this is not negotiated, Ms. Bostic, have you been able to work out the computer problems?
Judge, which Johnson?
Say it again.
Which Johnson?
Yeah,
Marcus.
Johnson, position 27. Are you with me, Ms. Bostic?
Yes, Judge, I am. I'm pulling it up. I'm sorry.
Okay.
It's coming up.
Yeah, while she's doing that, Ms. Dillingham, can you go ahead with the facts, please?
Yes, Your Honor. This case occurred in April 26th of 2022. Officers responded to the victim's residence at 682 Gordon Place Southwest. The victim in this case is Michael Johnson, the defendant's father. The victim and the defendant were having an argument, which led to the defendant choking Mr. Johnson. And when police arrived, they noticed that he was injured. We do have 2 other violent arrests in 2019 for battery family violence, and another one in 2022 for battery. So for that reason, the state was recommending 12 months to serve, 46 days, credit for time served, 23 days, balance probated with the FVIP program, a stay away order from the address 682 Gordon Place, and no further contact with the victim, Michael Johnson, as well as no drugs, alcohol, or weapons, Your Honor.
I have on the calendar, it says no further violent contact. Are you all requesting no further contact?
No further violent contact, Your Honor. Thank you.
Okay. Yes, Mr. Bartels.
Yes, Your Honor. I've spoken with Mr. Johnson about his case. And the only aspect of the state's recommendation that we would ask the court to reconsider is the FVIP program. As the court knows, that's a 24-week program. I believe the classes are $35 each. And, you know, there's no dispute that this is not an intimate partner relationship. You know, I'm not sure that it's his father. I'm not sure that FVIP would be the best thing here. He does get services from the DeKalb Clinic at Wind Way. So he sees a counselor there. And if the court were to make continuing with that a condition of his probation, as well as anger management rather than the FVIP, 8 anger management or 12 anger management classes, that would make a difference of, you know, about $420, I believe, if the classes are $35 each. And given the nature of their relationship, the fact that he is in school, I'm advised that he's enrolled in the Dunwoody campus at Georgia State and has been taking classes in economics there. I'm also advised that he is employed at Bridgestone Tire. So given those demands on his time and his financial situation, I think continuing to get the services he's getting at Wynn Way, as well as anger management, would be appropriate. I understand that it's classified as family violence because it's his father, but as the court knows, that can be deviated from if there's a good reason.
Wynn Way, what type of counseling is he receiving?
That's through the DeKalb Community Services Board based on his diagnosis. He sees a counselor and is on medication there.
Has anyone is this 682 Gordon Place, is this his father, Michael Johnson's residence?
I believe so. That's correct, Mr. Johnson.
Yes, Your Honor.
And he is still living at that residence?
I'm advised that he can stay with his mother or he can stay with friends.
Well, this, Ms. Dillingham, has your office spoken with Mr. Johnson regarding his?
We were unable to get in contact with him, but we are aware that he's still living at that residence. The victim is still living at that residence, so we would ask for the defendant to stay away from that location.
And I'm advised, and Mr. Johnson, you can correct us, but we had discussed that you not living there would be okay. Is that correct?
No, I've never lived there. I was visiting my dad.
Okay. Yeah. So a stay away from the location, I think, would not be an issue.
Okay. Mr. Johnson, it's my understanding that in case 22 CR 008248H, you wish to plead guilty to simple battery, family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I am going to accept your plea, Mr. Johnson. The court sentence is going to be 12 months to serve 46 days, credit for time served 23 days, balance probated, a 12-week anger management course. You're to continue counseling that you're receiving at the Wynn Way address. You're to stay away from the 682 Gordon Place address. You're to have no further violent contact with your father, Michael Johnson, no drugs, alcohol, or weapons while out on probation. And I'm going to waive the probation fees for you while you're on probation, but I'm going to require that you be on probation for the entire, reporting probation for the entire 12 months.
Okay.
All right. Good luck to you, Mr. Johnson.
Thank you, Your Honor.
Position 20, Griffith.
And this is a negotiated plea.
That's correct, Your Honor.
Good morning, Mr. Griffiths. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Griffith. Ms. Dillingham?
Yes, Your Honor. This case occurred on December 26th of 2020, where the defendant was trespassing at a Walgreens located at 25 Peachtree Street Southwest. The defendant had previously received a trespass warning and was asked not to return, to which he did. So for that reason, the state is recommending 12 months to serve, 18 days, credit for time served, 9 days, balance suspended, and a stay away from that Walgreens location at 25 Peachtree Street.
Mr. Bartels?
Yes, Your Honor. That is the state's offer that Mr. Griffith is accepting. I've discussed the case with him. I will get the plea paperwork to the court and other parties in the clerk's office today. And he does understand he can't go back to this location while that sentence is in effect.
Okay. Mr. Griffith, it's my understanding that in case 22 CR 008519J, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and if by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you to plead guilty?
Not at all.
Okay, I'll accept your plea as negotiated, Mr. Griffiths. Good luck to you, sir.
Thanks, sir. Thank you.
Let's see, for North, we have the Madam Interpreter on the line with us. Do we still have the young man that needs an interpreter this morning?
Yes, he's out.
Okay, can we go ahead and who's tell me who that is? Who's representing the?
I've got that case, Your Honor.
Oh, okay.
Really simple communication to him of the offer.
Okay, so are we gonna need, you're not gonna need to speak with him anymore, are you, Mr. McLean, or do you need to speak with him?
I just need to make sure that he understands about the $250 fine or 25 hours feature of it. He has a limited understanding of English. We didn't get very far in our discussion.
Okay, I'm just asking you, Mr. McLean, because either you're gonna have to get to Ford North if they will allow you to do that so that you can be with your client and speak in private with Madam Interpreter.
That's the way to do it, I guess, Your Honor, is for me to run up to Ford North. Can y'all get me up there?
Yeah.
They can get me up there.
Okay, all right, so let's get that accomplished at the most opportune or convenient time. So you all just let me know. Thank you. Okay.
And Your Honor, I understand that number 5, 6, 7, 8 will be probably the last in terms of timing.
We do have a private attorney, our position 45.
Okay, so thank you, Madam Interpreter. We'll be with you. We appreciate you joining us this morning. Thank you as always.
You're welcome.
Thank you. Where would you all like to go next?
Can we do position 17, Fuller?
Okay.
Fuller's just simply a not guilty. We would waive the formal reading of the accusation and ask the court to write it.
Good morning, Mr. Fuller. I'm Judge Eric Morrow. This is a state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Is that a yes?
Yes, yes.
You can put your hand down. Thank you, Mr. Fuller. You've been charged in case 21 CR 004881A with harassing communications. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding that Mr. McLean is waiving the formal reading of the accusation. How do you plead, Mr. Fuller? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you will get notification of your next hearing date. Good luck to you, Mr. Fuller.
Position, this is the probation case. Position 1, Mr. Watkins.
And after we did the probation case, Mr. Cowan has been waiting very patiently for us this morning. I believe his position is position 45. Can we, at an opportune time, get his client before the court, please?
Position 45.
Is this, it's Wilson? I don't know if is that at the South Annex?
Your Honor, she is now at the city jail.
Okay. Good morning, Mr. Cowan.
Good morning, Judge.
So we'll see if we can locate her at the earliest opportunity. I just saw you there and I wanted to see if we could have your client brought before us, but do we know where Do we know where she's gonna be this morning? Francois?
She should be at the South Annex.
Okay,
That's not my understanding, Judge. I believe she was brought to the city jail over the weekend or a few days ago to the newer facility.
is this Ms. Wilson here?
Yes, Your Honor, this is her.
Okay, why don't we go ahead and do Ms. Wilson since we have her there, then I'll come back to the probation case in just a moment. What are we gonna do with Ms. Wilson today, Mr. Cowan?
Judge, my understanding is that she is before the court on a motion to forfeit or to violate her pretrial division of misdemeanor bond that she's on now. There is a felony charge that involves the same victim that she is presently awaiting a bond hearing on.
Okay, so as far as this charge, case 22 CR 002038G, the battery family violence, I guess is the only charge that we have before the court this morning. And what is counsel proposing to do with this today?
Well, Judge, you're asking me, I would say continue this matter until until we know the outcome of her felony unindicted matter. We have a bond motion pending in that matter.
All right, so what we'll do, if you'll file a written waiver of arraignment in the matter, then we will consolidate these, and this case will be returned to the division judge, and I take it that the other case will be, will go there also. So if you'll just go ahead and file the waiver, I'll return it to the division judge, and she'll get notification of her next hearing date.
Thank you, Judge. And what case number are we using? State court case number?
22 CR 002038G.
Thank you, Your Honor. And can we just confirm with Ms. Wilson that she is indeed in Union City?
I've got that she's at the
Here at the South
ACDC South Annex.
Is that Union City or is that the old city jail?
It's the city jail in Atlanta.
Okay, very well.
Okay.
Ms. Wilson, I'll come to the jail to see you. Thank you, Your Honor.
All right, have a good day.
You too, Judge.
Thank you. All right, so let's go to the probation case. Good morning, Ms. Harris. Hope you're well. Happy New Year.
Your Honor, how you doing?
I'm doing well, thank you. Let's see, Mr. Watkins. Good morning, sir. I'm Judge Eric Morrow. This is the probation revocation calendar. Go ahead, Ms. Harris.
Yes, Your Honor. Mr. Watkins was sentenced to probation on October the 17th, 2021 to complete the domestic violence course and 90 hours of community service. As of today, he has not reported to our office. The only thing that was provided to us was an address. So he had a court hearing with Judge Porter on May the 25th, 2022, and he failed to report to that hearing. That's why a warrant was issued. Mr. Watkins' probation has 3 months and 10 days remaining. Probation's recommendation is to revoke the remaining time on his case.
Mr. McLean.
Your Honor, in this probation revocation, he does throw himself on the mercy of the court, and the reasons are this. He bit off more than he could chew when he agreed to the FVIP. This young man has been a homeless person for years on the streets of Atlanta. He has no income whatsoever. His hopes in getting somebody to assist him in applying for disability for mental issues was dashed when the volunteer person, a retired accountant at First Presbyterian, which has a homeless program, died. And he became depressed after that person with whom he had become attached and hopeful he was going to get moving on his life. He rarely, but occasionally, is able to work some small jobs. This is not a person who's going to be able to do much of anything in the way of probation conditions. And he survives on the street every night. So we would ask the court to consider something less than 3 months and 10 days.
All right, I am going to accept the probation's recommendation. I'm going to revoke the 3 months and 10 days so that he can get this behind him and move on early in the year with the rest of his life. So, given that he has not done anything, Mr. McLean, it's hard for me to not revoke the time. If he had done something, or if he'd reported, or if he had stayed in touch or anything, but given that he pled guilty to these charges, but did not do anything that he said he would do, I find that I think it's best to revoke the time. So that's what I'm going to do. Good luck to you, Mr. Watkins.
Understood, Your Honor. Thank you.
Next, Your Honor, can we do position number 39?
Yes, we can. And Ms. Harris, if you'll get me the paperwork, I'll get it signed.
Yes, Your Honor. As soon as I get the petition from the public defender's office, I'll be more than happy to bring it over to you.
Okay, and if you don't get it to me today, I'll be here tomorrow also.
Okay, no problem. That
Sorry.
concludes my business. May I be excused, Your Honor?
Yes, have a good day. Thank you. I'm sorry, tell me again where we are.
I'm sorry, Judge
39.
Miles, can we, while they do South Annex, can we do the breakout for North and the Spanish interpreter? And then Mr. McLean is gonna be in here.
Okay, all right, so we'll put courtroom 2 along with Madam Interpreter and 4 North into a breakout room.
Correct.
Right.
Thank you,
Okay.
Judge.
All right, and why, well, if we do that, then we don't have any public defenders, right? Because
My last case, Your Honor, I believe is position 39 with the South Annex. So if we can knock her out, I think then we can do the breakout room if that works.
okay, you all just tell.
She's the only one here, she's the only one here for him, so that would be helpful.
Okay, all right, so why don't we just go ahead and do that, and tell me who we have there?
Position 39.
39, okay, thank you, and this is a non-negotiated plea.
Yes, Your Honor.
Good morning, Ms. Schuler. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Honor.
Thank you. Can you raise your right hand for me? Swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, Ms. Schuler. Let's see, given that this is non-negotiated, can I get his history? Or her history, please?
Judge, I just got back on. Which defendant is this? I'm sorry. I'm
This
so
is-
sorry for the complication.
You're fine. Position 39, Ms. Schuler.
Give me just a second. Pull that one up. Schuler.
Yes.
Your Honor, I do have her history. We do only show that there's one prior arrest if we would like to. So
Thank you, Ms.
just
Todd.
retrying that.
All right, thank you, Ms. Todd. So if you can give me the facts, Ms. Todd, thank you.
Yes, Your Honor. Officers were dispatched to 4715 Frederick Drive in response to a call on suspicious activity. When the officer arrived, he did spot a vehicle in the parking lot that was rocking back and forth. He shined his flashlight in the vehicle and did observe the defendant engaged in sexual intercourse. The defendant does have a prior 2019 prostitution conviction. Therefore, the state is recommending 12 months to serve, 44 days, credit for time served, 22 days, with the balance probated. We are also recommending a sexual deviancy evaluation and treatment, as well as a stay away from 4715 Frederick Drive.
Okay, Mr. Doris.
Yes, Your Honor. At the time of this alleged incident, Ms. Schuler was 18 years old. This incident occurred in 2018. Before this incident, she was actually in foster care and had run away, and as you can, if you check the warrant, you can see that she returned as a missing emancipated juvenile out of Talladega Police Department in Alabama. Miss Schuler left foster care. She was barely 18 years old, and she struggled to find her way at the time. And she made some poor decisions, but she's not the same person that she was almost 5 years ago. And I want her to be able to get back on track and put this entire situation behind her. I know she had another issue in 2019, as we heard from the state. But since that time, after speaking with Ms. Schuler, I've seen that she's gotten back on her feet. She has family support with an aunt who I have her contact information. She has stable housing in Morrow, Georgia, and she provides for her now 2-year-old daughter. Ms. Schuler also recently got her barber's license and anticipates that she can keep working. I don't want to do anything that hinders Ms. Schuler's ability to keep succeeding and keep providing for her daughter. And so I'm asking, with the age of this case, Ms. Schuler's, place in life at the time and the time that's elapsed, we're asking for this just to be the 12 months to serve, 44 days with credit for time served, 22 days, so that Ms. Schuler can put this behind her and continue providing for her family without this lingering over her head.
Ms. Schuler, it's my understanding that in case 19 CR 009766H, you wish to plead guilty to one misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your plea, Ms. Schuler. The court sentence is going to be 12 months to serve, 44 days, credit for time served, 22 days, balance suspended. Good luck to you, ma'am.
Thank you, Your Honor.
All right. You have any questions, Ms. Schuler? You good?
No, sir.
Okay, all right, good luck, ma'am. Okay, so what would you all like to do now as far as the breakout room goes?
There's also a private attorney for position number 2 on the line.
Okay. So we can put courtroom 2, Madam Interpreter, and 4 North into a breakout room now.
Okay, Judge.
Okay, and so we'll go back to the South Annex here. Who do we have?
We have position number 36.
And this is Ms. McLeod's case.
Yes, Your Honor.
Ms. McLeod, are you with me?
I'm having a little bit of difficulty with my camera, Judge. I don't know if you can hear me.
I can hear you, Ms. McLeod. Good morning.
Good morning.
What are we gonna do with Ms. Sensley this morning?
He was on 2.
Now I can't hear you, Ms. McLeod.
Your Honor, I have not had a chance to speak with Ms. Sensley yet, Your Honor, and I did not see an offer concerning her from the state.
I have the office 12 months to serve, 60 days, credit for time served, 3 days, balance probated, an FVIP, no further contact. Is that right, Ms. Todd?
That's correct, Your Honor.
Ms. McLeod, given that this is not going to be a time served offer, do you want time to speak with Ms.
I do, Your Honor. I do want to
Can we
speak to her.
reschedule this for next Tuesday?
It was rescheduled to this day because Ms. Cloud was out.
Okay. Ms. McLeod, are you with me?
I am with you, Your Honor.
Okay.
The court said to reschedule the case for next Tuesday.
That would be my suggestion. It's up to you. What would you like to do?
It would be fine with me, Your Honor, because I would need time to speak with her.
Okay, so we'll reschedule it for next Tuesday, 1:10. All right. Ms.
That would be
Sensley.
fine for me, Your Honor.
Okay, we'll see you back next week, Ms. Sensley.
And I would like her to call me, Your Honor. I would
Okay.
like, I'm gonna put my number in the chat for her to call.
Okay. Where to next? Jail court
21.
21? Okay.
Mr. Hightower.
And let's see, I think that all of the public defenders are in the breakout room. So we'll have to hold on Mr. Hightower until they come out of the breakout room.
Okay.
Mr. Weinstein, who are you here for?
I'm here for Mr. Amos, position 2, I believe.
Okay, and do we have Mr. Amos?
I don't think he's been brought to the Zoom in the jail, Your Honor.
Okay.
But we can proceed without his presence.
What do you plan on doing with Mr. Amos this morning?
The only thing we'd like to do this morning is get the bench warrant lifted, Your Honor.
Okay, did he miss a court date?
He did. He missed a court date on January 3rd, 2019. He's currently in custody. We've paid the bond. We're just asking for the bench warrant to be lifted. I believe he has a hold in Houston County. So I guess he would be transferred to Houston. But he is at no risk of fleeing the jurisdiction or not appearing. He simply missed his notice. I guess he didn't receive his notice for that prior court date.
Your Honor, I'm sorry to interrupt. Has there been a waiver of appearance filed in this case?
No, we're gonna wait for him to get here. There's not been a waiver of appearance filed, is my understanding, but we have the courtroom that is in a breakout room right now. I was trying to get some understanding of what we were gonna do this morning. Now that I have the understanding, we'll wait for Mr. Amos to be present before we proceed, okay?
Okay, Your Honor, thank you.
Okay. And I guess we will have to be in recess until courtroom 2 comes back.
And Your Honor, if I may, while we wait,
Yes, Ms. Duncan.
I don't believe that Mr. Amos is in bench warrant status. I'm seeing that his case is currently active and he's being held on these 4 counts.
It was in bench warrant status. We have to open it back up once they get picked up on it.
Okay, let's wait till Mr. Amos is with us to address. Thank you.
Understood.
For his charge.
Good morning, Ms. Watson Cafe. Hope you're doing well. Happy New Year.
Good morning, Judge. Happy New Year.
Let's see, your client is, Mr. Langford. What were we gonna do with Mr. Langford today?
My understanding is he still in custody? My understanding is he's still in custody.
I believe so, yes. Did you get the offer? You're on mute, Ms. Watson Cafe.
Sorry, Your Honor.
I'm sorry.
I don't believe that I have an offer. If it was sent this morning, I've been in court, so.
Okay, you're fine, you're fine. Have you had a chance to speak with him?
No, not this morning.
Okay, the offer is asking for additional jail time, is my understanding, 12 months to serve 64 days, credit for time to serve 16 days. Would you like time to speak with him and get with the solicitor's office, given that it's not going to be a time served plea, and maybe we can reschedule for next week?
Okay, that will work, Your Honor.
Is that acceptable to you?
Yes, Your Honor.
Okay, so this is position number 31, Mr. Langford. We will reset him for next Tuesday, 1:10.
Oh, okay.
Okay, Ms. Todd, you're the solicitor on this.
Yes, Your Honor.
Okay, so if you can get with Ms. Watson Cafe prior to that time and see if we, to see what else she needs.
Okay, it will either be myself, Mr. Walker, or Ms. McCutcheon who reaches out.
Okay.
Okay.
All right. Anything further, Ms. Watson Cafe? Thank you for joining us.
No, Your Honor. Thank you.
Okay, I'll see you next time.
All right, thanks. Bye.
Let's see, it's almost 11 o'clock and we do have a bench warrant calendar at 11. Is anyone with us for the bench warrant calendar? Mr. Travis Walker?
His counsel was on the call earlier.
I did see him earlier, and I know we've reset this a number of times to get some clarification. I don't see him right now, so I'll wait till 11 o'clock to see if anybody appears. Okay, I just wanted to see if we can move something while we're waiting. Thank you.
That person dropped.
We have an announcement in case number 9 and case number 10.
Okay, what is the announcement?
Not guilty, jail jury. We'd like to arraign that. We will waive formal reading of the accusation.
And Madam Interpreter, if you raise your right hand for me, do you swear affirm that you will interpret from Spanish to English and English to Spanish to the best of your ability?
Yes, Your Honor, I do.
Okay, thank you. You can put your hand down. Good morning, Mr. Casimiro. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Buenos días, señor Casimiro. Soy el juez Eric Morrow y esta es la audiencia de listas de causas estatales de todo tipo y estamos conduciendo esta teleaudiencia para evitar el contagio. ¿Está de acuerdo que continuemos de esta manera?
Correcto.
Correct.
Can you raise your right hand for me?
¿Puede levantar su mano derecha, por favor?
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
¿Jura o afirma que la declaración que dará ante este tribunal será la verdad, toda la verdad y nada más que la verdad?
Sí.
I do.
Okay, you can put your hand down. Thank you.
Puede bajar su mano, gracias.
Mr. Casimiro, you have been charged in position number 9 with criminal trespass and position number 10 with loitering and prowling.
Señor Casimiro, usted ha sido acusado en la posición 9 con un cargo de por estar haraganeando y merodeando y el segundo cargo por allanamiento de morada.
Each of these charges carries a maximum penalty of 12 months in jail and/or $1,000 fine.
Estos cargos regularmente llevan una condena de 12 meses en la cárcel o una multa de hasta $1,000.
It's my understanding that Mr. McClain is going to waive formal reading of the accusations.
Entiendo que se van a leer los hechos de la acusación.
How do you plead, sir? Guilty or not guilty?
¿Cómo se declara usted ante estos cargos? ¿Culpable o inocente? Not guilty.
We will record your not guilty pleas. Your case will be returned to the division judge and you'll get notification of your next hearing date.
Vamos a grabar su declaración de inocente y este caso llegará al juez asignado para tratar su caso en la próxima vez.
Good luck to you, sir.
Mucha suerte, señor.
Gracias.
Thank you.
And thank you, Madam Interpreter. We appreciate
You're
you
welcome,
being with
Your
us
Honor.
today. Thank
Have
you.
a good day.
Oh, Mr. Campbell, just stand right here for me. Judge, next we have Mr. Campbell, position 8.
Oh, I need to talk to him a bit first.
Still gotta talk to him?
Yeah, that's totally fine.
We can go to position 21.
Can I ask a question? Did Ms. Cafe Watson, did she show up for this conflict attorney up here on 4 North?
Yes, she did, and we have reset her case until his case until next Tuesday, January 10th. She'll be in touch with him. Who do we have now?
Position 21.
And this is going to be an arraignment.
Well, we can waive arraignment, Your Honor, but this is Mr. Hightower, number 21. He is pleading not guilty and requesting a jury trial.
Okay, and you'll file a written waiver?
That's correct, Your Honor.
Okay, all right. So, Mr. Hightower, your case is going to be returned to the division judge and you'll get notification of the next hearing date, okay? Have a good day, sir.
Okay. Good luck, sir. Thank you.
What date is that? What date is that?
You'll get notification. There's no set, set hearing at the present time.
Thank you, Your Honor.
Okay. Let's see. Do we have anyone else in courtroom 2?
We still, need to do position A, but, Mr. McLean is, interviewing his client.
Okay, and what about Mr. Amos, position number 2? Do you all still have him there or not? I've been told by Ms. Lewis, and correct me if I'm wrong, that Mr. Amos has posted bond on this matter, and that he might have already been transferred somewhere else. If he has posted bond already, then we simply need to, if there's no objection, withdraw the failure to appear.
I'll check, Judge, I'm not sure. Hank Norris, do you know anything about that?
And Mr. Weinstein, do you have his correct address? We do. I do show that his notice was returned. I want to make sure that that we have a good address for him in the system for next
Judge
time.
Morrow, I'm getting ready to go get Mr. Amos, position 2.
Okay, thank you.
And yes, Judge, to be clear, there is no failure to appear case attached to this one as far as I'm informed.
Okay, so, and if he has already made bond on it, then what more needs to be done?
I would assume nothing. The state made an offer in this particular case, but I would defer to Ms. McCutcheon.
Judge, yes, Judge, if he's already been transferred to another jurisdiction, he's already served time on the FTA, then the state's position would be that the FTA then should be null prost. Let me just verify with Ms. Lewis or Mr. Jordan. Is that typically what occurs, Madam Clerk?
Yes, Judge, yes, Ms. McKitchen.
Yes.
This is an old bench warrant, so before we went to the new process of the FTAs with the new bench warrants, so he got picked up on it, made a new bond, and he's being transferred to another agency from understanding from what has a hold on, but this is the old ATCR, so we weren't doing the bench warrants as we were doing now, so there's no MP, no process needed to be submitted for this case. He just made a new.
Okay. All right, then. Thank you, Judge. Then, so I guess it's just a moot matter then.
Right, and that bench warrant was for Judge Porter.
Okay, so anything further on Mr. Amos, given what's come to light?
So I
don't
want
believe
to,
so.
I just want to clarify, Your Honor, there is no bench warrant outstanding at this time, that's become moot.
Okay, that's my understanding. Is that correct?
Yes, that's correct, because
Okay.
he made a bond with First Choice bond company on the charges that he was held in jail on January 2nd. He made the $4,000 surety bond.
Yeah, that's correct. I know the bond has been paid. So he's being transferred to Houston. Is that what's happening right now?
That's the hold that he has on him. Yeah.
Okay. Do y'all need his correct address?
Yeah, you can file it with the clerk's office, or you can send it to me in the chat to make sure we have a good address on record so it can be updated. And as long as the attorneys associated with the case, which you are, your office will get notification also.
Okay, may I ask who's speaking, and I'll send it to you in the chat.
It's Katrina Lewis. I'll send you
Okay.
my email.
Thank you. I'll send that to you in the chat.
Okay.
Okay, thank you. And once that's done, have a good day.
May I be excused, Your Honor?
Yes,
Thank you very much. You have a good day too. Happy New Year.
you also. Thank you. And I guess I saw earlier, I saw Attorney Jerome for the Walker case. It's 11/11. Is Mr. Walker on the bench warrant matter present, or Mr. Jerome?
I don't see either.
And Judge, just to make the court aware, both Ms. Duncan and myself did receive an email, and I responded this morning to Mr. Jerome, but I've not had a response, but that was via email. I will reach out and see if perhaps he's aware that he should be on the Zoom.
He was here earlier. I saw that he was, and I know that I reset this last week for today's date. So thank you, Ms. McCutcheon. Was he inquiring about an offer?
He was, Judge. He was inquiring about a plea offer as well as the status of the bench warrant, and I responded to his inquiry in the email. But I'll email him back and ask him if he could kindly jump back on the Zoom.
Thank you. Officer Norris.
Yes, Your Honor.
We don't need position 2 Amos anymore. We were able to deal with him. So I'm sorry. I know that Francois.
Yeah, she went to go get him. She did a little footwork.
Okay, well, he's not needed now, so thank you. Sorry about that.
Not a problem. Is there anyone else that we need? Are we waiting for?
Position 5, 6, 7, and 8. Ready. Campbell.
Yes, Your Honor. That is a negotiated plea.
And we're also looking for position 34, I believe.
I think we handled position
Oh,
30.
yeah, we handled 34, position 40, and 41.
Yes, Your Honor. I was waiting to see if he'd appear on 3 North. I've had trouble getting in contact with him. That might be a reset for the competency calendar, but we can address that after the.
Okay, all right. And is this Mr. Campbell here?
It is, Your Honor. Jerry Campbell Jr.
Okay, and what are we gonna do? These are gonna be negotiated, please?
Right, on 5 and 6, it's going to be a fairly simple plea of time served, balance suspended, stay away on those 2, and that will cause 7 and 8 to be null crossed, I believe.
Okay. Is that correct, Ms. Duncan?
Yes, Your Honor, that is correct. The state's offer on position 5, which is the case ending in 456J, is 12 months to serve, 38 days, credit for time served, 19 days with the balance suspended, and a stay away from North Avenue MARTA station. The factual basis for that recommendation.
I think that they're going to stipulate to that, Ms. Duncan.
Understood.
We do stipulate to the 3 elements necessary for the plea, and it is our understanding of the plea bargain offered. Thank you.
And what about position 6?
And the state's recommendation for position 6 ending in 471J is time served with the balance suspended, stay away from 3393 Peachtree Road, which is Lenox Square Mall. No further disruptive or disorderly contact with Officer Castro.
And Your Honor, he understands that a MARTA station is a pretty big piece of property, and that Lenox Square is pretty obviously a large piece of property. He is intending to stay away from both.
Okay.
He currently, I'm sorry, as far as I can see for position 5, he does have a current MARTA suspension that was issued on October 24th, 2020. I'm sorry, never mind. We can't, that was already expired. And the state did agree to null pros the FTAs if the offers were accepted.
Okay. Good morning, Mr. Campbell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Thank you, Judge. Good morning to you as well. Yes.
Thank you. Good morning. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down. Thank you. Mr. Campbell, it's my understanding that in case 22 CR 004456J, you wish to plead guilty to disorderly conduct. And in case 22 CR 004471J, you wish to plead guilty to disorderly conduct. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
Oh, Your Honor.
I'll accept the pleas as negotiated, Mr. Campbell. Good luck to you, sir.
Thank you, sir. Thank you, Your Honor. Have a good one. Happy New Year.
You also.
Thank you, Your Honor. That concludes my business. If I can be excused, I will drive back to downtown and start emailing y'all stuff.
Okay, and once we do the last, and do we know what is going on with, I guess, position 41?
Yes, Your Honor, for 40 and 41, it's a time served offer. I understand that Mr. Sotelo was uncooperative when he was brought in. I tried to meet with him yesterday, and the officer told me he was fearful of his life if he left his cell, so I wasn't able to meet with him. I was hoping he might be in a better mood today and would appear on the 3 North Zoom video. I don't think having a social worker visit is gonna help, so I just asked to reset to the competency calendar.
Okay, and when's the next competency calendar?
Are they doing a RegGT? But the next one is going to be a good one too. If you're talking about 2 weeks out, it'll be January 12th.
January 12th work?
That's fine for us, Your Honor.
Okay, we'll reset to the competency calendar for January 12th.
Thank you.
41.
Yes, 40 and 41. And I think that handles the 9 o'clock calendar. So when Ms. Lewis is ready, we'll go over that calendar.
Okay, can everybody hear me? All right, start with position number 1 is reset for the notice, and it's been released. Position number 2 is reset for the notice for trial. Position number 3, defendant is waiving arraignment. Case is reset for trial for the notice. Position, the same announcement on position number 4. Position number 5 was a plea. Position number 6 was a plea. Position number 7 is going to be null pros. Position number 8 is going to be null pros. Position number 9, defendant reset for trial for the notice. Defendant was arraigned. Same announcement on 10. Defendant was arraigned. The case is reset for trial for the notice. Position number 11 is reset for SAP 110. Position 12, same announcement, cases reset for SAP 110. 13, cases reset for SAP 110. Position 14, 110, reset for SAP. Position number 15 is a plea. Position number 16, defendant waive arraignment, cases reset for trial for the notice. I'm sorry, defendant was arraigned, cases reset for trial for the notice. Same announcement on 17, the defendant was arraigned. Case is reset for trial for the notice. Position number 18 is reset for SAP 110. Position number 19, waiver arraignment is going to be filed. The case is reset for trial for the notice. Position number 20 was a plea. Position 21, cases will be set for trial for the notice, waiver of arraignment is going to be filed. Position number 22, reset for the notice, defendant was released. Position 23, set for trial for the notice, a waiver of arraignments will be filed. Position 24 was a non-negotiated plea. Position number 25 was a plea. Position number 26 is non-pros. Position 27 was a non-negotiated plea. Position number 28 is reset for SAP 110. Position 29, same announcement, set for SAP 110. Position 30 was a plea. Position number 31, reset for SAP 110. Position 32 was a plea. Position 33, defendant was arraigned. The case is reset for trial for the notice. Position 34 was a plea. Position 35 was a non-negotiated plea. Position number 36 is reset for SAP 110. Position 37 is reset for SAP 110. Position 38, reset for SAP 110. Position 39 is a non-negotiated plea. Position number 40 is reset for the competency calendar for January the 12th, same announcement of 41. Position 42, defendant was arraigned, case is set for trial for the notice. Position 43, reset for the notice. Position 44, same announcement, case is reset for the notice. Defendant was released on 44, and 43 was a pro se. Same was 42 was pro se. Position 45, defendants, attorneys can file waiver or arraignment, case is set for trial for the notice. 46 was a plea. Any questions or any concerns?
No.
And please make sure you file all your non-process to me in a timely manner, and any plea paperwork to me. I have put my email in the chat for those who do not know me.
Okay, and Ms. McCutcheon, any word from Mr. Jerome?
Your Honor, let me check my email. I sent him an email. Let me see if he's responded.
I'm currently giving him a call, Your Honor.
Oh, thank you. I did not have a phone number for him, Ms. Duncan. Thank you.
Your Honor, I think that concludes my business, if I may be excused.
Yes, have a good rest of the day. Thank you.
Likewise, thank you, Your Honor.
He's not responded to my email, Judge. He emailed me and it reflected that it came from his phone, so I do not know if that means he's just unavailable physically. But Ms. Duncan says she's calling him.
Okay. Well, what we'll do, as Ms. Duncan calls, we'll just, if he wants to get back on the calendar, he can make a request. As such, I believe that I'm not sure if the bench warrant is still active or not at the present time, but
I believe it is still active, Judge.
So he'd want to get back on.
I'm sorry, Your Honor, I'm on the phone with his office now. She's going to get him.
Is the client on? I mean, on the line?
I do not believe so, Ms. Lewis.
Okay.
Your Honor, his legal staff said they're going to put him back on the Zoom in a few moments. He had another appearance, but he should be back within a few minutes.
Okay. We will, thank you, Ms. Duncan. And courtroom 2, I think we're done with your services, so thank you all. Anybody's there. All right, we'll be in recess for a few minutes to give Mr. Jerome the opportunity to get back on the line.
Would you need probation? You don't need to stay on? No.
I'm not sure, so if you'll stay on with me.
I will. Thank you.
All right, I'll see you all this afternoon. Officer Norris, mate. Okay, thank you. I appreciate it. We'll be in recess.
Your Honor, I'm currently on the phone with Mr. Jerome. He's stating that he's waiting to be let into the SAP calendar.
Okay, can we let him in, please? Do you see him there, Ms. Grace?
No, sir, not yet. Let me look up.
Attorney Jerome, they don't see you.
Okay, I see. Let me see.
I do not. They see you now, so I believe they're letting you in. Travis Walker is there as well, but I believe they're letting you in
Yes.
also.
All right.
All right.
All right, good morning, Mr. Jerome. Hope you're well today.
Yes, I am. And yourself, Your Honor?
I'm doing well, thank you. I think that when we left this last time we were here, the state was going to get in touch with the alleged victim regarding where she lived, and you were going to get with the state. What progress have we made in those regards?
Your Honor, in that regard, we were not able to make current contact with the victim in this case. We've done everything that we could, ran clear searches, sent text, left voice messages, and we were not able to make contact with the victim at the numbers provided and the information provided in the clear search. However, that number was used in the past to make contact with the victim in this case, where she detailed the assault against her and the brutality that occurred, as well as the defendant pulling out a firearm, but subsequently not pointing it at her. So that was the actual last contact that we had, but she's not been able to be contacted since then at her numbers that are provided or the ones that were found in the search that we run for this particular victim.
And Mr. Jerome?
Yes, Your Honor. And so we would just like to make our request again that the court lift the bench warrant and allow Mr. Walker to come in for, or just set Mr. Walker down for a final plea calendar. I tried to work out a deal with the state, but they insisted on waiting till after this hearing to see what the result of this hearing is. That being said, Mr. Walker has been staying with his mother. We have given the new updated address for his mother, and we will be filing a motion to amend the bond conditions so that he can go back home.
And Your Honor, as previously stated by the state, this defendant has FTA'd several times. Initially, he got on Zoom and admitted that he had been living with the victim at the Stayaway address. He initially changed his address to the Stayaway address. And the last time we were before Your Honor, his counsel did state that I believe he was staying with his grandmother. And then it was that he was staying, nobody was at that address in general. There have been no orders as of yesterday for a bond modification. And we would just ask, given this defendant's history and everything that's going on in this case, and the grace of the court has extended with no change in circumstances in our concern, particularly for the victim's safety in this case, that bench warrant not be set aside. This defendant does have violent convictions in his history and is a multi-state offender. So that would be the state's position on this case, Your
Honor. Mr. Walker has been on Zoom with me at least 3 times. He's shown up every time. He was on time every time. I'm going to give him one more opportunity to show up. So I am going to set aside the bench warrant at this particular time. I won't do it again, Mr. Walker. If you do not show up at your next court hearing, then a bench warrant will not be set aside in the future, at least not from me. Mr. Jerome, if he wants to go back there, you understand you'll have to file that modification. That will be returned to the division judge for them to modify that if that's the case. You've informed the court that we do have a good address. So with that being said, if you will send to the court the order to set aside the bench warrant, I will get that signed. This is your last opportunity, Mr. Walker, okay? And I'm only, at this point in time, I'm doing that because you have shown up for this court every time that we've requested for you to be here. Okay.
Your Honor, respectfully, Your Honor, I know the one lawyer wants, since I'm supervising Ms. Duncan, Judge.
Oh, no, you're fine, Ms. McCutcheon. You're
Okay,
fine.
thank you, Your Honor. We'd ask the court to please continue the condition, reinstate the condition that the defendant is to have no contact whatsoever, direct or indirect, with the victim in this case, Ms. Tashonda Dixon, and that he is not to return to any residential address where she lives. Judge, it's my understanding on behalf of the state that the defendant admitted that he had been residing with the defendant, and that's a direct violation of the stay away condition of his bond. So we'd ask the court to make the defendant aware that that condition is still in place, that he is not to have any contact with her and not to return to any residence where she is currently residing.
And that was my understanding. It was my understanding at prior hearings that, and that's why we've continued it, to see if we could get in touch with the victim, to see if we could find out if she was still staying there. The representation was made to the court that she was not. I suggested to Mr. Jerome that he seek a modification, which apparently he's going to do. But you understand, Mr. Walker, until all this is straightened out, you cannot have any contact whatsoever with the alleged victim, okay? All right.
Thank you, Your Honor.
Yes, thank you all. So if you'll get that to me, Mr. Jerome, I'll send that to Katrina Lewis. I will get that signed. I certainly think that you'll do that post haste so that that can be set aside. With that said, you all have a very good rest of your day. We appreciate it as always, okay?
All right, thank you, Judge, and Happy New Year. Glad to see you survive the holidays, Judge, and we're back to normal, safe and sound.
You also, I'm glad that you survived your trip to your daughters.
I
Right?
did. Happy
Okay.
2023 to everyone.
All right, y'all have a
Good day. Good day.
Happy New Year, Your Honor.
Bye-bye.
Mr. Amos' case. Can you tell me the status of Mr. Amos' case?